The Indian Child Welfare Act provides for tribal jurisdiction exclusive as to any state over child custody proceedings involving an Indian child who resides or is domiciled within the reservation or a ward of a tribal court of such tribe. The child's tribe has exclusive jurisdiction over the proceeding unless such jurisdiction is otherwise vested in the state by existing federal law. In the event of a transfer of jurisdiction from state to tribal court, state officials should continue to work on the case until the state court officially dismisses the case from state jurisdiction. State and tribal courts should work together in order to make sure dismissal and transfer of information is done quickly and to ensure the well-being of the child. Even when the Indian child is not domiciled or living on the reservation, the Indian Child Welfare Act recognizes that Indian tribes maintain jurisdiction over child welfare matters involving tribal children. At any time, the child's tribe, either parent, Indian custodian, or the Indian child's tribe can make a request orally, on the record, or in writing for the foster care or termination of parental rights proceeding be transferred to tribal jurisdiction. This applies to involuntary and voluntary foster care and termination of parental rights proceedings, including adoption, including termination of parental rights, pre-adoptive and adoptive placement proceedings. When a petition to transfer has been made, the state court must ensure that tribal court is promptly notified in writing and may request a timely response of the tribal court's agreement to transfer. A keystone of ICWA is the recognition of the tribe's exclusive or concurrent jurisdiction over child custody proceedings involving Indian children. The state court is required to transfer unless either parent objects, the tribal court declines to transfer, or the state court finds good cause to deny the transfer of jurisdiction. Any party to the child custody proceeding must be given the opportunity to provide the court their views of whether good cause to deny transfer of jurisdiction. The denial is not made on predictions of the outcome of the proceeding and other prohibited considerations stated in the regulations. In determining whether good cause exists, the court must not consider as evidence whether the foster care or termination of parental rights proceedings is at an advanced stage in the trial, whether there have been prior proceedings involving the child for which no petition to transfer was filed, whether transfer could affect the placement of the child, the Indian child's cultural connections with the tribe or its reservation. Finally, the court may not use the socioeconomic conditions or any negative perception of tribal judicial systems or social services. The good cause determination should address which court is best positioned to adjudicate the child custody proceeding, not predictions about the outcome of that proceeding. The basis of any state court decision to deny transfer should be stated orally on the record or in the written order. If the tribe accepts jurisdiction of the case, the tribe and state should communicate and work together to transfer the proceedings seamlessly and expeditiously to minimize disruption of services to the family.